Hello, everyone, and welcome to Legally Speaking Podcast. My name's Alla, and today I'm here with,
I'm Gali.
and we have a very special guest joining us. If you'd like to introduce yourself.
Thank you very much. My name is Berfu Beysulanangan. I'm a PhD researcher at the Faculty of Law, Energy Law Department, and also at the Groningen Center of Energy Law and Sustainability.
Today, we'll be having a very interesting discussion on the intersection of energy law and international investment law. So, let's dive right in. So, Berfu, could you please tell us what is energy law?
Energy law is basically the legal field that deals with all types of energy sources and also all steps of the energy chain. So what do I mean by energy sources? I mean all types of sources, renewable energy sources such as wind, solar, and also traditional non-renewable sources such as fossil fuels, natural gas. And when I say the energy chain and all steps of the energy chain, I mean from the beginning where we explore and discover and extract an energy source to the end where we actually use this energy in our homes, in our cars, in our factories. All steps of this process is basically dealt with by the energy law. So these rules can apply to various issues. For instance, who owns natural energy sources, or who is entitled to extract an energy source, or when a dispute arises between an investor in the energy sector and a state that owns a natural energy source, how is this dispute going to be resolved? All these issues are within the scope of energy law.
That's really interesting. And you said that you are also doing research on this field. Could you also elaborate on your research and what your research entails?
Well, as you mentioned in the beginning, my research is in the intersection of investment law and energy law. In that, I am working on how can we actually balance the right to regulate and investment protection principles within the scope of the offshore wind energy sector. So I will break this down to make it more clear. So as we all probably know, Paris Agreement set the goal of reaching net zero greenhouse gas emissions by 2050. So, of course, we cannot do this when we as the world are still depending on fossil fuels, hydrocarbons. When I say hydrocarbon, I mean oil, coal, and natural gas. When we are basically depending on these sources for energy, then it is not possible for us to actually achieve the energy transition, which is what we call the transition process from renewable energy sources to, non-renewable energy sources to renewable energy sources. So we need to have an energy transition to be able to actually reach these goals. And how will that be possible? How can we actually use all our energy from renewable sources? Offshore wind energy comes into play here because offshore wind, meaning the energy that is taken from the forces out in the sea, for wind forces out in the sea, transformed into electricity, and it has a vast amount of energy, much more than onshore wind turbines, because the uninterrupted winds in the seas provide a vast amounts of potential for energy. So many countries with costs that are basically appropriate to create offshore wind energy farms see this as one of the most important components of the energy transition. So many countries, including the Netherlands, have plans to build, they have already built, they are already building new ones, and they have plans to build more offshore wind energy production facilities, storage facilities, distribution systems, transmission systems. But of course, as you can imagine, this does not come cheap. These projects are major. They need incredible amounts of money to be invested in the very beginning of the project, and the projects are basically quite long. The amount of time that is needed for a project to be actually active and actually producing energy and profits is very long. So states alone cannot bear the cost of this alone. So this is why they are encouraging and promoting private investors to go into these sectors as well. And this is why private investors invest in the offshore wind energy sector, because governments create encouragements, advantages to investors that are actually investing in these areas. So this is where my research comes into play, because as you can imagine, these are big projects that require a lot of money, a lot of time. They have various technical difficulties and complexities. It is new technologies that are in play. And also within these circumstances, you also deal with private investors who want to obviously profit, and states who obviously want to make sure that these projects are built properly. So these circumstances create a situation where disputes may arise between private investors and states. And when these disputes arise, it is very difficult to balance the interests of the states, which is the public interest, and the interests of the private investors, and both are under certain circumstances equally important. So what I'm researching is how can we balance these interests without harming and actually ensuring the energy transition, ensuring more offshore development. How can we create a balance here in the offshore wind energy sector? So this is what I'm trying to look into, but obviously, as you can understand from all these explanations, it is quite complicated and there is no simple answer here.
Yeah.
Right. And
can I ask what drew you to Groningen in the first place? I know it's because the Netherlands has a lot of wind turbines, obviously, but do you have any other reason?
Well, honestly, it was very organic in that I was working as a lawyer. I was actually, when I was working as a lawyer, more focused on commercial law, contract law, and commercial arbitration. But I was trying to keep up on the commercial arbitration and general arbitration case law. And the more I read about the case law, the more I started seeing arbitrations about the energy sector, and then renewable energy sector, and then offshore wind energy. And they seemed very interesting, and the disputes seemed very complicated, and the decisions were very different from each other, very inconsistent. So I thought, well, this is very interesting, and these inconsistencies don't seem to be helping much. So this is a very interesting area of research. And then when I was looking into potential places on where I can actually do this research, obviously Groningen was one of the top places that came up, because not only the Netherlands has a lot of offshore wind development and interests in the renewable energy transition in general, Groningen itself we are right next to the North Sea, and the North Sea is basically one of the most developed places in terms of offshore wind energy in the world. And the energy law department in this university, as a result, is quite big and has valuable researchers and valuable research is being done. So this was the driving factor of me actually choosing this place to do this.
Yeah. Well, if anybody's interested in doing energy law here, I think you need to stay in Groningen.
This is a very good place for any researcher who want to do research in energy law. Also, any people who are just starting their careers, energy law, LLM here is also very, very interesting and would be a good place to start.
That sounds great.
You mentioned the Paris Agreement when you were talking about your research, and could you just state, like, briefly, or however you'd like to elaborate on it, what is the real significance of the Paris Agreement to your field?
I would say Paris Agreement to both my research and energy law in general is extremely relevant, obviously, because as I mentioned, it is where we as the world, because 195 countries, I believe, signed this agreement.
First of all, would you like to tell us what the Paris Agreement is for those who are not aware?
Well, basically, to put it in very basic terms, because this is not the part of the energy law that I'm focusing on, but Paris Agreement is basically the world, almost all of the world coming together and deciding what to do on climate change. It is the legal instrument that we currently have against climate change, because this is where the goals that we have, that we are currently trying to achieve, have been set. So the goal of net zero emissions by 2050 has been set within the Paris Agreement. So when I talk about the energy transition and the need for more offshore wind development and more investment in this area, the driving force behind the energy transition is Paris Agreement, because that is where all these goals have been set, and that is why the signatory countries are trying to actually realize these achievements. So this is why the Netherlands, for instance, is working very hard on developing more offshore wind, because they signed this agreement and now they need to actually achieve net zero emissions by 2050. So it is the legal instrument that we have.
All right. And is there anything else that you'd like to add regarding the importance of the Paris Agreement in the energy law field?
Well, this was actually what I would say as an answer to that question in the beginning anyway, because like I said, energy transition is currently one of the most important issues of energy law. It is what most of us are working on in some capacity. So as the driving force of the energy transition, it is of course quite relevant to all of us who are working in the energy field.
Of course.
In your research, you did mention things about the intersection between energy law and as well as international investment law. Now, could you give us a small primer or just a description about what does foreign investment mean for people?
Okay, so for this, I will start with what actually investment means and then go to specifics from there.
Yeah.
Yeah,
So
sure.
an investment is basically an asset or an item that an investor acquires for the purpose of generating income or for the purpose of increasing value. So the point or goal of an investment is to create wealth. This is what an investment is, and anything can be an investment if these are the goals, basically. So now let's define what foreign investment means. So foreign investment refers to investments that are made by real persons, real person investors that are not citizens of, or legal persons that are not incorporated in the country in which where the investment was made. So a very simple example would be a Dutch investor, for instance, a company that is incorporated in the Netherlands, investing in the US. This would be the investment of the Dutch investor in the US would qualify as a foreign investment. So why do we need the differentiation between domestic investment and foreign investment? That would be a valid question. And we need this because if it's a domestic investment, what I mean is if it's a Dutch investor investing in the Netherlands, then the laws of the Netherlands would apply. And we wouldn't have a question of what law applies here, what are the rules, does international law come into play? We wouldn't have these questions. But when it's a foreign investment, so when it's an investment, a Dutch investment in Dutch investor investing in the US, then we have to ask what rules apply here. Because will the Dutch investor trust only the US laws? They may not, as many investors don't. They don't trust other countries' investment laws. So this is why international investment law is a field, because this is where it comes from. It comes from international investment law, comes from the fact that foreign investors want to be protected in the countries in which they invest their money, a lot of money, especially in the cases of energy investments. So this is why we need this distinction between foreign investors and domestic investors. And if you want to define international investment law, then now it is easy to define it. It is the law that governs foreign investments and the disputes that arise out of foreign investments. So if the Dutch investor has an issue with the US about a regulatory measure that the US took, and the Dutch investor believes that this harmed the investment in some capacity, the Dutch investor can sue the US government, the US state, before an arbitral tribunal because of international investment law. So the legal sources of investment law would be, in this case, bilateral agreements, multinational agreements, international investment agreements, all these agreements. And this is a very complex system because I checked this. According to United Nations Committee on Trade and Development, as of March 2022, 2,805 international investment agreements were concluded at that time globally. And at that date, 2,242 were still in force. So when you talk about a foreign investment, there can be various agreements applying to that investment and various rules can apply. And obviously this makes for a very sometimes inconsistent and sometimes very difficult field to navigate in. And the relevance of investment law to energy law comes from the fact that, as I've mentioned, in energy law as well, there is investment because private investors are needed in renewable energy, not just renewable energy. This is what I'm working on, but obviously we know that, for instance, Shell is an investor in fossil fuels. So all energy sectors throughout have investors in them, and usually these are international foreign investors. So this is where the two fields come into play and actually have an intersection, because when it's an energy investment as well, we still are within the scope of international investment law. So this is where international investment law applies to energy sector and the energy law.
All right, thank you so much for that. And I think now it's time to dive into details a little bit. Could you tell us, what does the right to regulate mean?
Well, the right to regulate is basically a customary right of states to take any regulatory actions that they deem necessary for the good of the public or the public interest. This is grounded in the sovereignty and in sovereignty of states and international customary law. To put it in very basic terms, this terms refers to the fact that a state can basically enact or modify laws that it finds necessary for the public interest and in a manner that it finds fit or appropriate. So obviously, since I've mentioned that this international investment law is very complex and has like more than 2,000 agreements in place, obviously none of these terms, including the right to regulate within the context of international investment law, is very agreed upon by the general scholars, or it is not properly defined and accepted by the field or in the case law. So this is why it is a important subject to research, because we need to decide and we need to determine what this term means and then how it can be balanced against investment protection principles. Otherwise, when we are dealing with disputes in this field, we are creating a very inconsistent case law.
Yeah. And as a PhD researcher, have you kind of tried to define what this right to regulate means?
Well, this is what my first article will be about. My first article will be about what the right to regulate is, when do we see it materializing, what investment protection principles are, how do they materialize, and what do we see in the case law and in scholarly debate about how these two contradictory concepts can be balanced, and what are the inconsistencies that we need to resolve and how we can resolve them. Obviously, this is not an easy task. It is what at this moment I'm dealing with, and for the moment I have no specific answer. Okay. I am working on it.
And how long have you been doing this research?
Well, this is my 7th or 8th month since I've started, and bulk of this time has been basically working on what I've just described, writing of the first article. So literature review, forming my own opinions, looking at the case law, and basically trying to create some sort of a normative framework that can actually, in my opinion, create a balance here.
Oh, wow.
Yeah.
All right. And just to move on from the right to regulate and the inconsistencies with that, as you mentioned, hopefully maybe the following question will have more consistency in it. What are the investment protection principles that we mentioned?
Well, there will be no consistency here. I'm sorry.
I tried.
Investment protection principles are guarantees that are provided to investors within the scope of international investment law with, like I said, international investment agreements, bilateral agreements, multilateral agreements. This is because, as I've mentioned before, investors need these protections, or this was the belief when investment law was being built after World War II. Actually, no, World War I maybe. Yes. So this is when we were building this field, the point was economy was becoming global, investments were becoming international, but investors didn't feel safe to invest anywhere, because they didn't trust or know other countries' laws. So these guarantees are provided to investors via international agreements because they feel like they need them to invest in other countries. But applicable investment protection principles can change according to who the investor is, where the investment is, because the applicable investment agreement will change according to these. So, and every agreement has its own protection principles and has its own way of defining these principles. So again, there will not be proper, consistent case law here as well. Of course, there are some investment protection principles that are included in almost all of the investment agreements that are currently existing. But even the definition or the scope can differ. Even though they are mentioning the same principle, still the scope can differ. So again, there will be confusion in this regard as well.
So it's quite complicated to actually balance these.
Yes, exactly. Because how do we interpret these terms?
Yeah. And
If
which
we-
one do we use then?
Exactly,
Okay.
exactly.
Alright.
And in the previous two questions, we mentioned about, say, the state's sovereign right to control what happens within its borders in terms of investment. But we also have the other side of just foreign investors wanting to invest in said country.
Yeah.
Now, if we combine these two interests, these two, say, competing interests, is there tension there? What happens if there's, say, tension? And how does investment law deal with that?
Well, there is, of course, tension, and this is very important issue currently. Not currently, actually. I mean, currently, but also since the last decade or so in international investment law, this has been a subject of debate and discourse, and it may be one of the most important discourses in international investment law, because in many cases, in many disputes, we see that basically a foreign investor investing in a country, and then that country changing or amending its laws or taking some sort of a regulatory action, or in the investor's eyes not following through on a certain commitment, and then investment being harmed by this, and investors saying, well, I trusted these legal frameworks and these advantages that were provided to me when I was making my investment. This is how I did my risk analysis. This is how I calculated my projected profit and compensation of my investment. So now that you suddenly change this, I am harmed and I will not be able to recoup or have profits on my investment. And then they sue states for this and demand compensation. And in each case, basically the arbitral tribunals or courts have to deal with this question: how do we balance this? Because of course, there's no doubt that a state should be able to take any regulatory action that it deems necessary for the public interest.
Yeah.
But on the other hand, if states make specific commitments to an investor, for instance, to ensure that investment, then they should be held responsible as well, because in the end, they are using their right to regulate to make that commitment as well. So these are very, of course, complex issues, and we need to figure out which criteria do we apply here when we are resolving these disputes, so that we can actually ensure a balanced result, because sometimes it is in the interest of the public to protect the investment, and sometimes it is in the public's interest to say, no, this was necessary and this was the only way to do this, so the state was right to do this. So this, of course, is a very important issue. Like, for instance, the example that I gave, like with the Dutch investor and the US.
Right.
If the US suddenly changes the whole legal framework that applies to the investment of the Dutch investor, but completely and suddenly, should we say that, okay, well, this is the right to regulate and you deserve no compensation? Because this is a very drastic thing to do.
Right.
But on the other hand, the investor wouldn't be right to expect no laws would be changed ever, because that's not what the law is. And any investor should know that. Any prudent merchant should know that. Of course, life changes, technology changes, circumstances changes, the way we look at public interest changes. For instance, environment maybe was not in the forefront of our idea of public interest 30 years ago, but now it is.
Yeah.
So all these have to be taken into consideration when we decide how do we balance these interests.
So it's really about risk analysis on all parties and kind of considering, oh, as an investor, I need to be aware that the state could change its mind, simply put, or as a state, I also need to be aware that the investor could change their mind, for example. Would that be correct?
Well, yes, this would be correct. And this is actually, we can see this in the case law as well. Not all case law, because again, it is inconsistent, but some case law takes into consideration whether the investor actually did proper risk analysis and whether the investor could actually expect this change.
And does the risk analysis come from the side of the investor, or does it come from the side of the state? Does the state also need to consider these things?
Well, of course, states need to be reasonable when they're taking regulatory action. And also there are proportionality tests that are applied to states' actions in this. What I mean is, was the action that the state took for a specific purpose, for instance, for environment, was the action that they took was the appropriate action? was the action, was it the correct action to actually take the state to where it wants to go? Like, was it fitting to the purpose? And was it proportional? Were there other actions that could have been taken that would be less severe for the investment? These are the responsibilities on the state side. And on the investor side, of course, first of all, they, like I said, any little change cannot be expected to be a basis for a demand of compensation, because it is not reasonable. These investments, especially in the energy law, the investments lifespans are very long. We are talking about 20, 30, 50 years. So you cannot expect, especially in a field like energy law, where everything keeps changing because technology is changing, where the law keeps changing because of this. You cannot, as an investor, reasonably expect that no law will be changed. But of course, there are things that investors cannot foresee. Or sometimes states make these changes so suddenly, without any grace period whatsoever. Of course, then I would say, well, investors at least have to be given some sort of a time period to actually adjust to this. So it's all based on the specific circumstances for each case you really need to look at, because there's no possibility of making a blanket statement and saying that we should just do this and this would solve all problems. That is not possible.
Yeah, and so in these types of, say, commercial dispute resolutions, is there a way for states as well as foreign investors to kind of have maybe a third party or, say, an international institution to help, say, negotiate or to help mediate, to help arbitrate these two competing interests?
Well, of course, this is where arbitration comes into play. One little correction. I would say these are not commercial dispute resolutions because a state is involved.
Right.
So when two private parties are involved, it is commercial. But here we are dealing with not commercial arbitration, but what we call investor-state arbitration. And this is what the majority of the disputes in the energy sector are resolved, because most of the investment agreements, at least the majority of them, include clauses that allow foreign investors to submit their disputes to arbitration against states. So majority of the disputes are resolved by arbitration, and this makes arbitration in the center of this discourse regarding this tension between the right to regulate and investment protection principles, because in the end, that is where the disputes go, and that is where the specificities and specific circumstances of each case is being looked into and interpreted. All these investment agreements are being interpreted by arbitral tribunals there. So that is why arbitration would be in the very center of this issue.
And what are some, say, criticisms towards investor-state arbitration in this context?
There are a lot of criticisms towards investor-state arbitration and international investment law in general regarding how they're dealing with these disputes. One would be fossil fuel industry using arbitration, investor-state arbitration, to basically make states pay incredible amounts of compensations to them. So and this would result in states being a bit more hesitant to take actions to ensure the energy transition. Because when you say, I will not, for instance, as a country, you decide that you will no longer allow coal as an energy source. This would be a very good thing to do in terms of the energy transition, obviously. But what will the coal mine investors do in this case? They will, of course, sue the government for this and demand compensations. And these compensations, since the amount of investments are very large, imagine a coal mine or a nuclear power plant. These are huge investments with huge values and huge margins of profit. So the compensation amounts are quite big enough to even make a state hesitant to actually make sure that the energy transition happens. So this is one of the main criticisms, especially from the side of scholars and people in general who want the energy transition to be achieved as soon as possible. There are, of course, other criticisms as well, such as the inconsistencies that I've been mentioning, because, of course, it is not great when a case law is so inconsistent that you cannot find a proper definition or proper interpretation of many of the core terms of that field. That is not great. This comes from the fact that arbitrators are not bound by the previous case law. So they basically make their own interpretations and own implementations for each case that they are assigned to. So they don't have to look at the previous case law and say, oh, this is how this term was interpreted here, so that is how I'm going to interpret it as well. This is not to say that they're not looking into previous case law at all. They of course do, but they're not binded by it. So they can diverge from the previous interpretations easily, and this would not be an issue. This is another important criticism. And also another criticism would be the calculation of compensation. What I mentioned in the beginning, kind of related. The compensations can sometimes be very, very large. For instance, again, I looked, and the biggest award that I found that was granted was against Russia, in the case Halley versus Russia, and the compensation was $40 billion. Oh,
wow.
Exactly.
Wow.
So then, of course, this brings the question of how are these compensations are calculated? Do we need to have a proper calculation system to ensure that they are calculated correctly? Because again, tribunals adopt different ways of calculating compensation. Some of them take into account certain aspects of the investments, and some of them say, no, this shouldn't be taken into consideration. And these all makes sure that, again, in the calculation of the compensation, the case law is inconsistent. And also another issue would be, of course, you probably wouldn't get such a compensation before a national court. So these are all criticisms towards arbitration and international investment law in general, because in the end, arbitration can be involved here because of the international investment law agreements that are in place. But of course, I'm not, at this point, I'm not really saying that I agree or disagree, because there are, again, two sides of all of this discourse. And in some cases, you see that maybe some criticisms are not really earned, but some of them are very true. For instance, fossil fuels industry's use of arbitration has not been great. But fossil fuel industry's general approach to law has not been great either. So this is, I think, a part of a bigger problem too. But yeah, this is another issue. And I think a balance between these two interests would actually help with these criticisms as well. Like it would help ensure that arbitration is a consistent and proper dispute resolution system for these specific disputes as well.
Has there been examples where, say, an international arbitration tribunal or, say, a trade agreement has generated a lot of contention between these two competing interests?
There have been very famous ones, actually, in Italy and Spain and in Czechoslovakia. I will mention the Spanish cases here. This is not one case that I'm talking about, but actually multiple cases that came out of certain regulatory actions that Spain took. So in 2007, Spain enacted laws to basically provide very generous advantages to renewable energy investors. This was for the point of creating more investments in the renewable energy sector in the country. And in this sense, this regulatory action was very successful because many, many investments were done in this period in Spain. Actually, in 2008, Spain was responsible for half of the world's new solar installations that year. So you can see that the laws that are enacted there were very successful for their purpose. But in the end, the advantages were so much that it was not possible to continue with them. And this resulted in renewable energy costs increasing in a very, very high rate in the country. And this also coincided with the financial crisis in 2008 in Spain. So the country had to take some action to make sure that its economy is protected and its energy sector is protected. So they took very drastic measures. They basically limited the advantages and changed the legal framework about this. And of course, the many investors that invested in the country, in the solar panels and solar farms in this country, trusting these advantages, complained and said, well, we have not got the compensation for our investments, let alone getting some profits, and we trusted these advantages when we all invested in this country. So then dozens of claims were brought against Spain in arbitration. And as these were dozens of different investors in dozens of different cases, even though they were arising out of the same regulatory action, the cases were different. And in each case, there was a different arbitral tribunal, which resulted in very different interpretations of the same regulatory action. And these were all happening simultaneously. So these cases actually proved the criticisms somewhat correct, because interpretations were inconsistent. Some claims were accepted, some claims were rejected. In the end, in total, 1.2 billion euros of compensation was decided upon for Spain to pay the investors. Spain did not pay these compensations because they decided to seek for annulment of these awards. Some of them are already annulled, some of them are, for them the process is still ongoing. But the importance of these cases come from the fact that the same regulatory action, the same circumstances. Of course, this is not to say as lawyers we should know that even though it comes from the same regulatory action, each case can differ in itself. Because, for instance, in one case, an investor maybe had a specific meeting with the Ministry of Energy in which the Ministry of Energy promised something to them. And in other cases, maybe one of the investors had something written that were promised to them. So, of course, we know that each case should be considered within the scope of its own circumstances, but still, this showed that, yes, arbitral interpretations are inconsistent and very different from each other, even when if it's about the same issue.
Wow, that sounds like a nightmare.
Yes.
Because the courts do need to take care of these very specific circumstances. And so, yeah, it does make sense that you can't treat them all the same. So that sounds terrifying.
Yeah, exactly.
Is there any other case that you'd like to mention?
Another case would be the Vattenfall versus Germany case. This is about the phase out of nuclear power plants in Germany. So Vattenfall is a Swedish company that had 2 nuclear power plants in Germany. And in 2011, Germany decided that it will basically phase out completely nuclear energy in its own country by 2022. So, of course, Vattenfall sued Germany in 2 different fronts, actually. One case in the German Constitutional Court and one case in investment arbitration. In both of them stating that we made this huge investment to these 2 nuclear power plants that you are now saying that we only have 10 years left in them, and that is not enough time for compensating the investment that we made and make a profit. So German Constitution Court decided in 2016 that the action of Germany to phase out nuclear power plants is lawful, it is within the right to regulate, but Vattenfall should still be compensated for the damages that it incurred. And at the time, the investment arbitration was still ongoing. And in the end, in 2021, Vattenfall and Germany settled the case. So this was basically settled outside of the arbitral tribunal. And 1.43 billion euros were paid to Vattenfall by Germany. And the importance of this case would be, like I said, the other industries' use of arbitration against countries' policies for the energy transition. There are, of course, arguments about nuclear energy and whether it's clean energy, whether it should also be included in the energy transition. I'm not going into that at all. There are different opinions on this, but in the end, Germany, among many other countries, decided that nuclear power should not be used in this new future that they find necessary. But the nuclear power plant owners managed to get 1.43 billion euros out of them for this. Of course, this is not great for countries who want to take drastic measures for the energy transition. But on the other hand, of course, when an investment is being made, if it's a new investment and Germany knew that if this was going to happen, they should have maybe not allowed the licenses for these nuclear power plants. Of course, again, each case is different and has to be like, this is very general summarization of the case, but it is still important to see that Germany was in fact acting for the public's interest and had to compensate a company for that. And is this right? Is the compensation amount too much? Like, maybe we agree that there should be some sort of compensation, but maybe the amount should be less. Maybe when it's for the energy transition, for the fight against climate change, maybe we should give more deference to the right to regulate, or maybe we shouldn't make a difference at all. But these are, of course, issues to discuss and debate.
And earlier also you mentioned, or you hinted more so at that there should be a balance between the public and the private interest. Could you tell us a little bit more about that, and also how can there be this or how can this balance be met, actually?
Well, of course there should be balance, but how is another question. I think at this point in my research, obviously, maybe in 3 years I will say something different, which is the nature of research. But at this point, I believe that we should be aware of the fact that, yes, private investors are motivated by profit. We know this because there are companies or individuals who are trying, like, the aim of investment itself is profit. So of course their motivation is profit here. Even when they are investing in renewable energy sector, it's still profit. On the other hand, states can also have motivations other than public's interests. States can do many things in the name of public interests, but is it really? And is it proportional? And is it the correct action? Because states can be corrupt, or there can be political interest. Maybe they want to be re-elected and they need money from a certain sector. All these things can come into play. So it is not possible to say that states are only acting in public's interest either. So we, as the people, need investments to be done in renewable energy sectors. And we, as the people, need the energy transition. And we, as the people, need net zero greenhouse gas emissions. So our focus should be keeping both of these parties in check and ensuring that energy transition is actually achieved, that we can still encourage investments in this area, but also we should be able to allow states to use this power, this valuable power, when it's in public's interest. This should be the focus. But it is not possible to make, at this point, at least for me, to make any blanket statements as to how we can create this. But my belief is we should question all parties, because in the end, like I said, other motivations can come into the decision-making process, and it can be harming the public's interests in some way.
And so, from my understanding, the public's interest is, or should be, in your belief, the forefront of this dispute, basically.
That is exactly what I believe, because in the end, why do I work on energy law and specifically in a renewable energy field? Because I want more investment being done there so that the energy transition can actually be achieved. This is all for the public interest, and I believe that should be the forefront, because, again, like I said, I don't think both of these parties have the public's interest as the first priority in their decision-making processes. So we should be careful in this discourse to say, just let's protect the right to regulate always, or let's protect the investments always, because that would not be very helpful for the public. So the focus should not be on one interest or the other, but it should be on the public's interest.
And that wraps up today's episode on the intersection of energy law and international investment law. Of course, this is but a brief overview of the topic itself, and we do encourage you to dive even further into this ever-evolving topic. You might as well just go to the energy law department in Rolling Building if you'd like, and that's definitely something that you should do.
Thank you for watching, and a special thank you to Berfa for joining us today. We hope that you enjoyed being in the studio with us. My name's Ala.
And Gali.
And we hope that you tune in to our next episode. Bye-bye.
Bye.
Bye-bye. Thank you.